We acknowledge the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. In accordance with Sections 45 and 53 of the Planning Act, 1990, as amended, this meeting of the Committee of Adjustment of the City of Toronto is called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning bylaw that apply to property, permission to extend or to alter the lawful non-conforming uses, and consents to sever property to create new lots. Anyone in attendance today who wants to receive a copy of the decision of the committee on an application must complete a decision request form. These forms are available in the hearing room at the end of the horseshoe. Please ensure that you include your email address on this form because the Toronto Local Appeal Board will be sending notifications and updates by email. Once completed, please give the card to committee staff before you speak or leave it in the black box at the end of the row where you are seated. You may not agree with the decision of the committee. Decisions may be appealed to the Toronto Local Appeal Board, otherwise known as TLAB, or in some limited circumstances to the Local Planning Appeal Tribunal. Application instructions are set out at the bottom of the decision of the Committee of Adjustment. To ensure a fair and timely hearing, I will vet the agenda to determine which applications can be dealt with immediately and which applications have individuals present other than the applicant who wish to address the committee. I will call each item in the order it is listed on the agenda and will ask for individuals to identify themselves. If there are people present in interest, the matter will be held until all the non-contested applications have been dealt with. So if an item is held, we strongly encourage the applicant or agent to meet with the interested parties outside the hearing room to discuss and or resolve the concerns or issues. If no person is present in interest, just the applicant, the item will be called in its order on the agenda for non-contested applications. Where an application is uncontested, the agent or applicant will proceed with their presentation if required by committee. The committee may ask questions and or take the matter into the committee for a decision. Each speaker, including the applicant or agent, will be given a maximum of 5 minutes to address committee. I will comment when your time is approaching the 5 minutes. When addressing the committee, please come forward to the podium and clearly state your name and address. Please remember to confine your remarks to the matters outlined in the application. If you have a written submission from which you read, please hand it to the Deputy Secretary Treasurer when you are finished. The applicant or agent will proceed first and will make a presentation to committee. Please note that the committee may not entertain extensive revisions to proposals at the hearing today. The committee may decide to defer the application if it is substantially revised to ensure that the revised application is accurate and that all those entitled to receive notice of the application are informed of the changes. Then, people in interest, either in support of or opposed to the application, will be invited to speak. If there are several speakers sharing the same view, please select a spokesperson to present the group's opinion. We want to hear your views, however, covering the same material and points is not required and will not advance your cause. Now, committee members may ask questions of each speaker. When all the speakers are finished, the applicant or agent will have an opportunity to rebut, However, that rebuttal is limited to the questions or issues raised by the speakers. This will mark the end of discussion. The application will then be taken into committee for a decision. So, let me just now ask if there are confirmation of minutes from the last meeting. Are there minutes for?
Yes, through you, Mr. Chair. The committee members of the last hearing have reviewed the minutes and have confirmed them with me. So we need a motion to have them accepted.
That is the meeting of what date, please?
Public hearing on
October 9?
November 6th.
November 6th. So could I have a motion, please, for adoption?
No, it's the other panel. They've reviewed them, and now we just need a motion to accept them.
So a motion, please, to adopt minutes of by Mr. Reid. Second.
I second. Yeah.
Second by Ms. Chang. Motion to approve those minutes. All in favor? Motion carried. Okay, closing files.
Through you, Mr. Chair, there are no files today to be closed.
No files to be closed.
Unless there's someone here that likes to withdraw their application. Doesn't appear.
Any requests to withdraw an application and close a file? Gentleman here?
No.
Oh. Okay. Now, deferral requests.
Through you, Mr. Chair, can we do declarations of interest? You need to ask the members if they have any declarations today.
I shall do that, of course. Let me just ask members and staff if there are any declarations of conflict of interest perceived.
No matter, Mr.
Not this session, no.
None. Hearing none, we shall proceed then to deferral requests. So, I would like today actually to vet the agenda first and then come back to deferral requests, having vetted the agenda. So that is my plan for today. So applicants and agents, people present in interest. If you are present today to ask, okay, so I'm going to vet the agenda now, going through the items listed, and this will be to determine that the applicant or the agent is here, and secondly, to determine if there are people here who wish to speak to that application, people in interest.
Through you, Mr. Chair, just before we begin, just for the people who are here on item number 1, we do know that there is a deferral request, so you will be the first deferral request dealt with after the chair vets the agenda, so we'll just go from there, because there are a lot of people, and maybe the other people who have deferrals or have people here contested, they can go out into the hallway while we deal with that first deferral request.
This will give an opportunity for applicants to meet with people here in interest and use that time productively. So, application number 1, 428 Lakefront. Applicant present. Thank you. And are there people here in interest on this one? Very good, thank you. So that'll be the first deferral request that we hear then, and it could also be held. Application number 2, 55 Ossington Avenue. Applicant, thank you. Anyone here in interest on that application? In opposition or support? Hearing no one, we move on to application number 390, GLEN EDYTH Drive. Applicant, thank you. Any person in interest? Yes, there is. Thank you. So number 3 will be held, and I encourage the applicant to meet with people in interest outside if they would like to do so. It's optional, but advisable to perhaps resolve concerns. Application number 4, 34 HURNDALE Ave. Applicant, please. Thank you. Persons in interest? Great. Number 5, 192 Hastings Avenue. Applicant, thank you. Persons in interest? Application number 6, 431 Concord Avenue. Applicant, thank you. Persons in interest? Yes, there are. So application number 6, 431 Concord will be held. Again, you may wish to speak with the applicant outside. Number 7, 159 to 161 Frederick Street. Applicant present, thank you. Persons in interest. Application number 14 DEWHURST Boulevard. Applicant. Persons in interest. Number 9, 7 Fraser Ave. Applicant. Persons in interest. Number 10, 603 CARLAW. Thank you. Persons in interest. There are parties here in interest on number 10, 603 CARLAW. It is held. Number 11, 116 Hamilton Street. Applicant. Thank you. Persons in interest. Number 12, 473 Woodbine. Thank you. Persons in interest. Number 13, 615 King Street West. Thank you. And persons in interest. Number 14, 305 Riverdale Avenue. Applicant, thanks. Persons in interest. Number 15, 256 Grace. Applicant. Persons in interest. Number 16, 12 Leonard Circle. Thank you. Applicant. Persons in interest. Number 17, 50 Carroll Street. Thank you. Persons in interest. Number 18, 387 Jane Street. Applicant, thanks. Number 19, 211 Avenue Road.
Mr. Chair, that's been moved to the 1:30 time slot.
Pardon me. So number 19 has been moved to the first item on the 1:30 time slot. And lastly, application number 20, 188 King Edward Avenue. 188 King Edward. Thank you. Persons in interest. Okay, so just to recap that, the following applications are being held. Application number 1, 428 Lakefront, it's going to be considered for deferral. Number 3, 90 GLEN EDYTH. Number 6, 431 CONCORD. Number 10, 603 CARLAW. Those three. Okay, we'll move now to deferrals and go through the list here. So, applicants wishing to request deferral of an application. Please come to the mic.
Thank you, Mr. Chair. For item number 1, we're going to be dealing with the deferral request. We've had one from TRCA and from the councillor. So if the applicant or the representative for the applicant can come forward, and maybe one spokesperson for the neighbors to speak to just the deferral. We're talking about the deferral. So if there's maybe you can come and sit up front, the person who will be speaking on behalf of the neighbors.
Good morning. Could you state your name and address, please?
Yes, it's Mike Pettigrew from the Big Leary Group. Our address is 121, or Unit 121 at 20 Leslie Street in Toronto.
And could you tell us your reasons for seeking deferral, please?
So we received the correspondence from the TRCA, would have been mid last week, a week before set for our hearing, that they had re-reviewed the plans after previously stating that they were in support of the variance. So in that amount of time, we've had some discussions with the TRCA. City staff has come out to the site as well. So we agree with the deferral to give us an opportunity to go back to the TRCA, see what their concerns were and any changes that could be made to the plans. And there might be a possibility to have some further discussion with the community.
Thank you very much. Okay, I'd like to hear now from the spokesperson for those in opposition.
Thank you very much, Mr. Chairman, members of the committee. My name is Dennis Wood. I'm with the law firm of Wood Bull LLP. I act for the two abutting owners to this property. And as you will see, there is a great number of members of the community that are here expressing a concern with this project. The request for a deferral is a sensible one, and therefore my clients support the idea of deferral, as it will give not only the TRCA but also the local community and perhaps the planning staff to take a further look at this project. So I speak in support of deferring the matter this morning.
Well, thank you very much. Appreciate that. Okay, then, in that case, look for a motion on this request to defer from committee. Is there a motion?
Yeah, I would move a motion to defer, but I would like to request that the applicant meet with the community as part of this deferral process, and have that as part of the condition of approval to defer.
Okay, motion to defer with the condition that the applicant meet with the community, seconded by Mr. Clay.
Do we have to put a statement to say that defer to the maximum of 3 months?
It'll be
okay. Yeah.
Maximum 3 months?
Yes, maximum of 3 months, at which point the application technician assigned to the file will be keeping in touch with the agent to make sure that you're on track, and then hopefully by the end of 3 months we'll be able to schedule it for another date.
Okay,
I would second that. Did you put?
It's been seconded by Mr. Clay.
Oh,
so
sorry.
We're good. All right. So there is a motion to defer. All those in favor? Deferral fee to apply. And so is that part of your motion, if I may?
Yes.
Okay. Deferral fee to apply. All in favor? So the motion is carried to defer the application as with those conditions. Thank you. Thank you.
Excuse me, if you would mind clearing the room fairly quickly, because there are people who would like to use the seats, and we need to move on with the rest of the agenda.
Our next application will be number 2, 55 Ossington. So you could
Yes, he's with me. Yeah.
You do not need a presentation. No, you're going to ask us first, right?
just wait a moment. Okay, on the application for 55 Ossington, the committee has before it the following communications: a copy of the plan of survey, site plan, floor plans, and elevations, email correspondence from the Assistant Planner, Heritage Preservation, a staff report from Heritage Preservation, and a letter of support from James McDonald, 53 Ossington. So, applicant, may I ask you please to state your name and address?
Pat Hansen, 55 Ossington.
Thank you very much. Now, panel, would you like a presentation on this application, or would you like to go straight to questions?
I don't have any questions either.
I don't have questions either. I have read through the file. Yeah. I don't need another presentation.
You don't need a presentation? Okay, there being no request for presentation and no questions, then I would look to panel for a motion, please.
Just, Chair, just making sure that the applicant has seen the staff report from Heritage?
Actually not.
Oh.
Okay, so maybe...
Okay, all right. Well, I'll look at it. I'm sure we can comply.
Well, you might want to just double check that. Do you want to have a copy of this?
Yeah.
And have a look at it? I think you should probably benefit from seeing what they're saying before we approve you.
the main meat of that is in the last paragraph. It's just talking about repairing the cornice line as part of your work.
Yes, that's perfectly reasonable request.
Okay.
Thanks.
Thank you very much. Okay, then. At this stage, then I can look to committee for a motion, please.
I'm happy to move approval, Chair.
Is there a second?
Subject to the conditions of the Heritage's November 14th letter.
Right, okay. Yeah. So motion to approve with that Heritage recommendation. All those in favor?
Thank you.
Motion is carried. The application is approved. Next application up is 90 GLEN EDYTH.
That's held.
Is held. Application number 4, 34 HURNDALE, please, applicant. Good morning. On this application, committee has before it a copy of the survey, site plan, floor plans, elevations, email correspondence from Development Engineering, Engineering Construction Services, and a form letter in support. May I ask you please to give us your name and address?
My name is Mike De Oliveira. I'm here from Replacement Design representing 34 HURNDALE Avenue.
Thank you very much. And on this application, I don't know that we need a presentation, but maybe perhaps go straight to questions?
No, I don't have any questions.
Yeah, I just want to make sure that, are you aware of the reviews from TTC, their November 6th letter with the conditions?
Yes, we're aware, and we've reached out to go through their review process.
Right, and you have no issues with that?
No, we're just in the middle of dealing with them.
Okay.
Yes. So I don't have any questions either. I know that the TDC is the only thing that they be aware of, but I'd like to move the motion if there's no questions and, to approve the application.
Motion to approve, second. Is there a second?
Second.
Second by Mr. Reid. All those in favor? The motion is carried. The application is approved.
Thank you very much.
Thank you. Move now to number 5, 192 Hastings Ave. Good morning.
Good morning.
On this application, we have before us a copy of plan survey, site plan, floor plans, elevations, and a planning rationale prepared by KFA Architects and Planners. May I ask you please to state your name and address?
Neha Kulkarni, and I'm the agent for 192 Hastings Avenue.
Thank you very much. Okay, then, on this application, committee care for presentation? Any questions?
Chair, I just have a couple questions, if I might.
Please.
I noticed the FSI is increasing considerably. What's it now? Do you know?
So the existing, I'm not sure. Do you know the existing FSI?
Just ballpark.
I think it's about 8.7 or 0.87.
Yeah, that's 0.87. Sorry.
Okay. I have a question too on the walkout from the basement is quite close to the sidewalk. Is there any risk there of any pedestrian risk created by that walkout?
I feel that we don't see any risk as such because the sidewalk is quite wide. And secondly, there has been precedent in the area where the access to the basement has been up to the lot line, and we have given about meter setback from the lot line.
It's about a meter setback.
Yeah, I think so.
Thank you.
I did notice that the entrance is on a front wall. Is proposed to be on the front?
Yes.
That's variance number 9?
Yeah.
Okay.
Okay. Any further questions of the applicant?
No.
In that case, I will look to committee for a motion, please.
I put forward a motion. I think the basement stairs have been well screened in this proposal, and I think in some the remainder of the variances are quite minor. So I would put forward a motion to approve.
I agree to that. That although it seems that there are a lot of variances, but most of them are because in the result of the existing condition.
Right.
So except the 4 areas increase. So I think that is still a reasonable development. I second that.
So you're seconding the motion. So motion to approve by Mr. Reed, seconded by Ms. Cheng. All those in favor?
Thank you very much.
Motion carried. Application is approved. Thank you. And we move on to application number 6. 431 Concord. Pardon me. 431 is held, I'm sorry. Which takes us to application number 7. 159 to 161, Frederick. Good morning.
Good morning.
May I ask your name and address, please?
Greg Quinn, representing the applicant for 161 Frederick.
On this application, committee has before it the following: copy of survey, site plan, floor plans, and elevations, 3 photographs of the underground parking, covering letter from Benjamin Rubin, decision number A0810-11 TEY affecting the property, and also email correspondence from the from Traffic Planning and Transportation Services and from Heritage Preservation Services. Okay, don't believe we need a presentation on this one. No. Are there any questions of the applicant, committee?
No.
In that case, I'll look to the committee for a motion, please.
I'm happy to move approval.
Motion by Mr. Clay to approve. Second on that? Second, Mr. Reed. All those in favor? Motion carried. Application is approved.
Thanks so much.
Thank you. We move to application number 8, 14 Dewhurst.
Good morning.
Good morning. Could I ask your name and address, please?
My name is George Popper. I'm the architect and co-applicant for the project.
Thank you. On this application, committee has before it copy plan of survey, site plan, covering letter from Justin Ackler, the agent, site-specific bylaw, and City Council decision number MM 6.2 from April 2019. Again, I don't believe a presentation is needed here. Committee?
Chair, this looks to be just a technicality, if
yes.
I could use that word, right?
That's correct.
Just to rectify.
It's an administrative error that we're rectifying now.
Right, okay.
Or we're asking you to rectify, more correctly.
Well said. With that, I'm happy to move approval of this requested variance, Chair.
I'll second it. Yeah.
Motion by Mr. Clay, second Ms. Cheng. All those in favor?
Thank you.
Motion carried. Application is approved. Thank you.
Thank you.
And now we go on to 7 Fraser Ave, application number 9. On this application, committee has before it copy of survey, site plan, floor plans, decision number A79118 TEY, and email from the third-party projects officer, third-party projects review at Metrolinx. Good morning.
Good morning. My name's Joshua Butcher. I'm an associate at Bousfields, and we're the planning consultants to the owner and tenant of this building.
Thank you very much. Okay, now, on application number 9, I don't believe a presentation is necessary. I'll look to committee if they have any questions of the applicant.
No questions.
No questions.
Just a clarification in terms of the final use. So you're looking to have retail, which is a permitted use.
It is a permitted use in an IC zone. In the Liberty Village area, there's a use qualification that restricts retail stores in this historically employment area. This is the headquarters of Decium, which is a manufacturer of beauty care, skincare products. Their offices are upstairs. They have manufacturing on the ground floor, and they're looking to have a small 186 square meter ancillary retail unit to sell their products.
So it's ancillary to the
It is ancillary, subordinate to the primary use.
And that is permitted?
Yeah, yeah.
Look to committee for a motion, please.
Oh, I will move to approve the application.
Motion to approve by Mr. Cheng. Second. Second, Mr. Reid. All those in favor? The motion is carried. The application is approved. And we move on to application 11. 116 Hamilton.
Good morning.
Good morning.
My name is Maggie Yong-Ji-O, and the property is 116 Hamilton Street.
Thank you very much. On this application, committee has before it copy plan of survey, site plan, floor plans, emails from assistant planner, community planning, and a support letter from 114 Hamilton. Okay. On this one, committee, I don't think a presentation is required, but certainly go to questions of the applicant.
I have none, Chair.
No question.
I think it's quite reasonable because the house next to it, 118, is actually sticking out even more, right? Yeah. But 114 does not object, so I think it's pretty, it's acceptable. The variance are minor. I'd like to move the motion to approve.
Motion to approve by Ms. Cheng.
Thank you.
Second, Mr. Clay. All those in favor?
Thank you so much. Thank you.
Application is approved. Thank you. And committee moves to application number 12473, Woodbine.
Good morning.
Good morning. May I ask your name and address, please?
My name is Eric Hiltonen. My address is 473 Woodbine Avenue.
Thank you so much. Okay. On this application, committee has before it a copy of plan of survey and site plan, 2 photographs of the front yard, email correspondence from Transportation Services, and also from Urban Forestry, and staff reports from Tree Protection and Plan Review Urban Forestry, and the Supervisor of Tree Protection at Urban Forestry. And there is correspondence in opposition from four addresses. So, there we are.
Sorry, you say opposition? Support.
I beg your pardon.
Okay, you can calm down now.
All right. Late submission.
I'm good now.
Correspondence in support or expressing no opposition.
Thank you.
Pardon me. All right, then. On this one, panel members, care for a presentation?
No, thanks.
Just a conversion into a parking pad, right?
That is correct, yes.
Mr. Chair, are they aware of the urban forestry condition?
Yes.
Yes,
there is an urban forestry condition.
I'm very aware of it. I've been communicating with them the last few days, working with Grant in urban forestry.
Okay. Urban forestry condition number 1 does apply. Okay.
And then there's the additional requirements that they've added in their recent memo that was sent on the 15th.
Yeah, they're additional to.
Yep.
Do they have?
I have a copy of all that. I've been communicating with that.
With the deposit for the.
Correct.
And tying to plans, and you're fine with that?
It's the 9,400 deposit.
Yeah, that's right.
Yeah, I'm
November
very familiar.
14th letter.
I'm sorry?
The letter from November 14th.
Yes, I am. If you have a copy of it right there, I mean, I'm pretty sure it matches my copy. But...
It'll be the same one.
Okay.
Yeah.
Have you, in terms of materials for the parking pad, have you considered what you're planning to do?
Yeah, absolutely. So I've been working with Stephanie Hong from Community Planning, looking at permeable paving. Just the concern of being Toronto, all the concrete. So she suggested permeable paving, and we're happy to comply.
Can we make that a condition of the approval?
Yes.
Sure.
Okay. So, any other, Chair? Is that okay? I'll move approval with the conditions from Urban Forestry and the condition that the material to be used will be permeable.
Okay.
I second.
Motion to approve, Mr. Clay, seconded by Mr. Reid. All those in favor?
Thank you kindly.
Motion carried. Application is approved. And we are moving on to application 13-615, King West.
Morning.
Good morning.
Chairman. My name is Armando Barbini. I'm the representative of the property owner at 615 King.
Thank you very much. Before us on this application, committee has simply a copy of plan of survey, site plan, floor plans, and elevations. And this would, to legalize the deck, the intention here is to convert the ground floor of the 2.5-story semi into an eating establishment and to legalize and to maintain the rear deck and front stairs constructed without a building permit. So,
I have
questions.
I have one question.
Yes.
It's only just technical. In the purpose of the application, you mentioned the ground floor, but the variance is mentioned the first story. Is it the same?
It is, well, that's the wording, yes. It is the same thing. It's a 2-story building.
Yeah.
And basement is about 4 feet out of ground. And then the first floor or ground floor, they're interchangeable words, but the bylaw requirement requires that the finished first floor be no higher than 0.6 meters from the sidewalk elevation.
Yes, I understand that.
Yeah,
I just want to make sure the first floor meaning also the ground floor.
It's the same thing. Yeah, they're interchangeable. Yeah.
Okay.
And approximately when was the deck in question built?
Well, the deck is actually the rear. I think there's some confusion with the building department. I know they put some notes in there, but there is no variances addressing the deck at the back or the porch at the front. Now, the deck at the back's been there about 15 years or so. The porch at the front was just recently built to match the one at 617. 617 did theirs, and they converted their ground floor in 2015. So what this owner did, I guess unknowingly, and he should have known, that he needed to get clearance first, but the one next door was constructed and was converted, the ground floor, to a poutine takeout restaurant, similar to what's being proposed here, a takeout restaurant. So he went ahead and built a deck at the front to match the one at 617. So, but there are no variances reflected with respect to that because the building itself is set back around 8 feet from the front lot line, and there's a 0 setback requirement. So, you know, I didn't clarify, I didn't question that so much because there's still no variance in it. It's just the wording, the way they worded it.
Thank you.
Yeah.
Okay. Just if I could build on that, Chair. So the stairs in front would meet code then, would it?
Yes.
Okay. And the deck in the back, was it your client that built it, or your client bought it from a previous owner?
I think he bought it from previous owner. He's owned it for a number, about 5 or 8 years or something like that.
Would that deck comply with code?
Well, it's been identified by the building department, so now they'll have to show drawings to illustrate that it complies with code, yes.
For you, Mr. Chair, so when something comes to legal, they have to get the permission from you first to legalize the variance, gotcha. And then that triggers them having to go and make it proper.
Yeah.
Thank you.
So in that case, I will move to approve this application.
Thank you. So motion to approve by Ms. Cheng. Is there a second? Second by Mr. Reid. All those in favor?
Thank you.
Application is approved. Thank you. 305 Riverdale, application number 14. Good morning.
Good morning. My name is Nathaniel Gray, and I'm the architect representing 305 Riverdale.
Thank you very much. On this application, committee has before it the following communications: plan of survey, site plans, floor plans, elevations, decision number A057714 TEY, a covering letter from Christopher Chan, the agent. There's also some commenting agency reports, email correspondence from Community Planning, City Planning, and a staff report from Community Planning received November the 1st. In support, there is a 17 signature petition. So, committee, do we wish a presentation on this one? No presentation. Carry on to questions then, please.
Morning.
Hi.
I know the chair mentioned it, but I just want to make sure you're aware of the contents of the letter from Community Planning, November 1st, tying if we were
the roof letter?
Yeah. Well,
yes, I'm aware of that.
Yeah.
Yep.
Tying the approval to the plans as submitted.
I am fine with that. Yep.
Okay.
One small question.
Yes.
I noticed you have a lot of support from many people, but what about 307?
307 is out of the country.
Oh, okay.
And we have a text message exchange with them that didn't go into the record because it wasn't a signature, but I'm happy to give you copies of that text message if you'd like.
Fine. So
okay.
They're fine with it?
The words are totally fine with the addition.
Oh, okay. That's my only question. Okay.
I'd like to move a motion then. I think this is a sensitive project, and obviously you have considerable support. So I'd like to move approval subject to the conditions from Community Planning in the October 31st letter.
Yeah, let me just confirm the letter date, but I'm sure, yeah, that's right.
Right. Okay.
Thank you.
Thank you. Motion to approve, seconded by Mr. Clay. All those in favor?
Thank you very much.
Application is approved. Number 15, 256 Grace Street. Good morning.
Good morning.
May I ask your name and address, please?
Yep. Good morning, Mr. Chair and committee members. My name is Adam Brander, and my address is 49 Bolton Avenue.
Thanks very much. On this application, committee is looking at a copy of plan of survey, site plan, floor plans, and elevations, and staff reports from Community Planning, Toronto and East York, and from Tree Protection and Plan Review. In support, there are 2 form letters, and in opposition, there is correspondence from 264 Grace, received on November the 4th. So, do committee members wish a presentation? No. Or carry on to questions then, if you wish.
Just to ask, the planning department recommend opaque screening on the deck. Will you agree to that?
Yes.
Condition? Okay.
Hi. You've seen the letter from the neighbor talking about front yard landscaping, I presume?
Yes.
I'm assuming you're not making any, are you making changes to the front yard?
There's no change to the amount of soft landscaping being proposed.
What's there now?
It's a porch and a pathway and a concrete pad. We have I guess I want to show you actually, if you look on the site plan, we could take a look in more detail.
Would you put that up on the overhead, please?
Yep. So if we look at the central property, that's the subject property. Sorry about the blurriness. The variance is actually just a condition on where the property line is situated, the front property line. So while it's very close to the house in this case, the majority of the front yard is actually landscaped if you include the actual landscaping up to the sidewalk. So all the dotted area there is landscaping. It's the extent of the hardscape is a access path and a porch.
So there's no parking on the front?
Correct.
And that percentage of front landscaping is an existing condition?
Yes, that's correct.
It's totally okay.
And it's only calculated within the property line, right?
That's correct.
Okay. I have no further questions. Then I will move to approve with the condition that the screen, putting opaque screen 1.5 meter on the north-south side of the deck.
And there is a forestry.
And the forestry condition number 1. Yeah.
Yep.
Okay, thank you.
I second that.
A motion to approve by Ms. Chang, seconded by Mr. Reed. All those in favor? The application is approved.
Thank you.
Thank you. And the committee moves on to consideration of application number 16, 12 Leonard Circle. 12 Leonard Circle applicant. Okay, take your time. On this application, committee has before it copy plan of survey, site plan floor plans, a covering letter from Adrian Latavsky, the agent, a decision number A047317 TEY, which affects the property. And from commenting agencies, we have reports from Community Planning, City of Toronto, and from Tree Protection and Plan Review, Urban Forestry. Thank you. Good morning. May I ask you to state your name and address?
Yes, my name is Adrian Latavsky. My planning firm is Johnston Latavsky. We are the agents for the applicant. Our address is 235 Lakeshore Road, Suite 2 in Oakville, Ontario. And I'm here to answer any questions you may have or give you a presentation if desired.
Thanks very much. Okay. Okay, panel, do we need a presentation on this? I don't think so. But your questions for the applicant.
Morning. So I see that this was approved in 2017 and now you're coming back for an additional FSI. What changed in that time period?
Well, it's a case of, well, as you know, the house was approved in 2017, as you mentioned. It is now actually under construction. Construction has begun. And my client has realized the opportunity to perhaps seek this additional density within the existing roof line as approved. And so let's call it a desire to change and expand on the approval that was there, recognizing the construction underway. So it's an opportunity, sir. That's really what it is. And the recognition that they can add additional space for the family, which I'm sure would be quite useful to them. And as I mentioned in the letter, it's an entirely reasonable variance, certainly in my opinion. And there you go.
Thanks.
Thank you. Further questions of the applicant?
So the FSI that was approved before, pardon me, you'll have to...
The FSI approved in 2017 was 0.67.
Right.
What we're requesting today is 0.8 times. And as mentioned, there's no change to the building envelope itself. It's just to accommodate it within the existing roof structure.
Yeah.
But you add the dormer?
There is an addition of a dormer and a small balcony out the back. There on the screen right here, you can see a floor plan of the proposed third floor and how it would fit within the existing roof structure.
And may I ask, is this with a secondary suite in mind?
No. I should perhaps just simply highlight just that the previous approval did have one condition attached to it, that the home be constructed in accordance with the elevation that was on file that's actually attached to the decision in 2017. So naturally, I raised this point because you mentioned about the addition of a dormer. Yeah. That dormer was not on that original elevation. So there is a change in that elevation as conditioned in the first decision. So if there's any desire or intent to retain that condition, please be aware of that one small change in the elevation.
So that dormer is on the set of plans that committee has before it now?
Yes, it's on the plans that are before you now. There is a front elevation. I can show it on.
So this is the application that we're dealing with now then, and that will show if that dormer is on here.
It's on the drawings right now.
Yes, it is.
So, Anita, we can actually erase the conditions that imposed by the previous decision, because the previous decision the condition is that they cannot make any changes to the elevations. Now, if we approve this, but he only mentioned the FSI, he did not mention anything about elevations. So can we say that they can revise the elevations?
The conditions that were granted in that previous decision were related to the proposal at this point and those variances.
Yeah, exactly. But then at that condition, they said they cannot change the elevations.
It doesn't say they can't change them. It says it needs to be constructed substantially in accordance with the elevations that were submitted at that time. Yeah. And has it been constructed?
Well, yes, the construction proceeded in that fashion, but now we're seeking the additional density, which would result in.
Are you in the process? Is it completed construction?
No, it's not. It's construction began, then was halted pending the resolution of this.
So they're seeking to alter the elevations and increase.
So technically, if it's not completed, those same variances should have all come back, because now you can't assume that the committee would have approved those variances. Right?
I'm not sure I understand.
Right. So the variances that you were approved for were for a specific proposal, and it was based on certain elevations, and the member is correct. That hasn't been completed. If it was completed and you were coming back and now adding this extra variance, what the zoning examiner should have done is should have included it all, because the construction is not complete. You're still operating under that first building permit, is that correct?
No, I would suggest alternatively that all of the variances that were approved in the previous application still stand and are still valid and have been complied with when it deals with, for example, there was a variance in that application for building height. There's no change in that proposal on the plans before you today. The only change that we are seeking is the additional density within the roof line. And so if there is any concern about any confusion or misunderstanding, then I would suggest to you then you can amend or impose, for that matter, or reimpose rather, the condition that the building be built. Be built, take the same wording as the front elevation there, and just be built in accordance with the elevation on file as per this application.
It hasn't changed. It's not going to change. You're not changing the roof line?
Well, my suggestion is the roof line is changing. There is the addition of the dormer.
Is the only change to the exterior of the structure the dormer? Is that the only change that exists on the two sets of drawings? One has a dormer, one does not?
If you can just give me a moment, I can show you.
I mean, it was only tied to the front elevation. If the front elevation doesn't change.
That's what it says, the last condition. I just want to make sure. I don't think it's a misunderstanding. It's only detail or clarification.
Right, but those variances.
It will be a contradiction
and now it's
all elevations.
2.5 story.
Making changes.
Okay, this may not be terribly clear.
You have that. You have that in your file.
This is a copy of the decision on file, and you can see the elevation of the home, and this was attached to the previous decision. So you can see the roof line there. Now.
It is the front elevation.
It would be up to the committee members to determine whether or not.
Yeah, it is a change. It's only a technical thing. I actually do not think that it makes the proposal any substantially different. But I want to make sure that technically we do not erase the condition that was imposed in 2017.
Well, you would be if
We have to.
if you tie it to that elevation.
Now I know.
Well, that's why my suggestion to you it might be that if the committee still wishes to have that condition on file and imposed, to simply amend that condition to reflect the elevation that's on file today.
Right. Which would mean the dormer would be removed from this proposal.
I'm not sure I understand this. So this is the proposal that's on file right now that includes the third floor and has the dormer on the roof line, and because the condition that's in place today refers only to the front elevation.
Correct.
And so
ties this decision today to that front elevation in the previous decision. That dormer has to go.
No, but my suggestion to you is that the committee has the power to impose a new condition that reflects this current elevation.
I understand what the applicant's saying. I think that we will simply include in our if this does go to approval, we will include in our motion that this approval be tied to drawing A2.1 submitted. That's the only drawing that really changes from the two sets.
Yes.
Yeah, but
I believe what the other member is saying is that the new house was permitted to be constructed on the condition that it does never have that dormer. And now it is not complete, and they're altering what the committee had originally considered in all those variances. Had that dormer been proposed at that time, perhaps the decision would have been different. Nobody will know.
Yeah,
It was approved, all those variances were approved on the condition that the front elevation appear as this. Now you need to decide whether or not your decision today, tied to this plan or tied to how it's going to substantially change. And that's entirely up to this committee to decide.
Basically, they have to supersede the other decision.
It's not superseding the other decision.
That is what?
It's not supersede. That decision stands.
Okay. Oh, it's still exactly because they still have.
Again, in my opinion, I believe that all the variances should have come back, but that's not how the zoning examiner reviewed it. Yeah. So now you're being asked to basically alter that decision. And does it substantially change the decision by adding this plan today? Is it minor? Is it in keeping with the character? All those things. So you keep it in mind, but you'll have to consider this based on what you have today.
On the previous application, the drawing reference number was the same. It was A2.1 back in 2017. And that is a condition number 3 of that approval. But I think we could simply, as part of our motion, add a condition that it be tied to the revised A2.1 submitted with the set of drawings on this date was that these were submitted in 2019.
I don't know. This is a technical thing because it really is making it very difficult for us because the previous condition did not have an increase of the FSI, right? So we're adding, we are approving a new one, but change the previous one. I think that Anita's point is correct. If it's come with all the variances, we can approve everything as revised. But we're only revising one thing and adding another, approve another variance. Technically, it's very difficult for me to agree to this procedure. It's only procedure. Personally, I do not think it's major change.
I would agree. I think that this incremental impact of the third floor living space and the dormer in the back balcony is minor, and I would be inclined to approve that. I just want to make sure that we're doing it technically in a way that can be enforced.
Because they still have to comply to the previous, all these conditions too, right? That's what. any suggestion we can fix this?
If I may address the committee.
Please.
In my opinion, and obviously we're all here to, you must resolve the matter to your own satisfaction. But in my opinion, the procedure has been followed with the various city departments, namely the building department, where a preliminary project review was secured to confirm the variance in question. And I can certainly only trust that the building department has reviewed it with, hopefully, your concerns in mind. And ultimately, only the one variance was identified. I hear Ms. McLeod's comment, and there are certainly, I'm sure, different ways that matters can be brought forward. But I would suggest that ultimately the end effect is to understand, and I believe this was the case with the preliminary project review, this understanding is implicit, that the previous approval in 2017 hasn't been changed. There's been no suggestion or request to change it or nullify it in any way, and that this approval is in fact supplemental to that previous approval. And I can only assume that the building department understood this and was okay with this, and I leave it to the committee to decide how best to reflect and perhaps I would suggest update the condition that's on file, whether it be, and I personally agree with the suggestion that the committee can impose a new condition with this decision, tying your approval to the specific elevation on file today, however it can be referenced best. And then I feel confident that when the time comes and the approval is secured, my client can take that back to the building department and secure the required amendments to the building permit and have this matter go forward with all appropriateness. That's just my thoughts for you to consider.
Thank you very much. Okay. Committee, anyone care to make a motion on this application?
Before we do that, Chair, just to confirm, I mean, it's not in our records from the previous approval, but I presume neighbors were in support, or there was no opposition to this, is by your recollection?
I don't believe there was really any opposition. There's certainly no opposition expressed today that we're aware of to this change. Are
they aware of the change you're making?
Yes, all notice was given.
Okay.
And I've been monitoring. Well, you have the file in front of you. There's been no objections filed.
Then they can still get the permit.
Mr. Chair, I think I'm hearing two members somewhat sympathetic to the nature of the change. It's more of a process issue, is what I understand, and I'd share the sympathy with the proposal. It doesn't seem egregious. It doesn't seem out of character. I noticed the roof line hasn't changed at all, so height isn't an issue. But I just wonder if there's a path forward in terms of rectifying the process to allow this project to proceed.
Well, the one that strikes me, if an application to approve was to be brought forward, I still think our best way forward, if we wish to do that, is to cite that, notwithstanding condition number 3 of the 2017 approval, that this approval, this 2019 approval, would be tied to revised drawing A2.1 dated the 20th of May 2019.
Secretary, is that satisfactory legally, or?
Can we put in a condition to say that this, the 2007, same, 2017 decision, all the variance, except number 3 is the FSI, and the elevation are revised to the today's submission. We can only, yes. But we do not, then we will not touch any other variances.
You could make a motion to that effect, yeah?
That today's decision approval is only for variance as listed, just that one.
Just number 3.
Number 3.
From 2017.
Yeah. And yeah, it doesn't make sense, right? I do not know how to say that the other variances in the previous application are still, yeah, they're not before us. That's what I mean. Yeah, in change of the elevation, which is.
So if we, for example, were to approve this, then it's up to you to follow up and find a path forward in terms of process. Is that correct? Would you be happy with that? That's what I understand.
Yeah, as I stand here right now, I feel confident that if you were to approve the variance as proposed, subject to the condition mentioned, that could be taken to the planning department and the building permit successfully amended.
Maybe that's the
building department, sorry.
Okay.
Right.
Yeah.
And let them resolve the. Yeah,
that's simpler, I think.
Okay.
Yeah.
We're punting.
No, I understand this is complicated. I'm not concerned with this from a substantive perspective, from a content. It's just more making sure you can build it. So I would put forward a motion. I think what makes most sense and gives you most flexibility is just saying a motion to approve.
Yeah, I'd second that.
Yes.
Motion to approve by Mr. Reid, second by Mr. Clay. All those in favor?
Thank you very much.
Motion carried. Application is approved. Thank you.
Thank you.
Good luck.
That was a good one. They learn, right?
And we move on to application number 17, 50 Carroll Street.
I'm back.
Good day, good morning. Do you mind repeating your name and address, please?
So my name's Joshua Butcher. I'm a planner with Bousfields, 3 Church Street, for the owners of 50 Carroll, the subject property.
Thank you. On this application, committee has before it copy plan survey, site plan, floor plans, elevations, urban transportation report prepared by the BA group, a planning rationale from Joshua Butcher, the agent. We have email correspondence from TRCA, dated August 29th, from Transportation Services Toronto, September 19th, and from Urban Forestry, Ravine and Natural Protection, dated 18 July. There's a staff report from the Supervisor of Ravine and Natural Feature Protection, and there is a report from the planner, TRCA, dated 22nd of October. In the form of support, there are 2 form letters from occupants of 777 Dundas East and 2 Matilda Street. So,
Mr. Chair, I wouldn't mind could you just give us a quick overview? This is a pretty.
Yep.
I went through this. It's lengthy. It's complicated.
Yep.
I think it boils down to being fairly simple.
It's fairly simple.
If you could just paraphrase what's in your proposal for
us. So essentially, this is an existing structure currently operating partially as a co-working office space and known as the East Room, and they are looking to renovate the balance of the building into additional co-working office space as well as an ancillary restaurant use. And I'm just going to flip the page here so you can kind of see what we're doing. So there are 3 areas to be renovated. And so Michael, if you just slide it over a bit, you can see the image on the left. So that's kind of a half basement level, currently vacant. And so there's going to be some office space in there. And then if you flip the page, there's an upper basement level, which if you just slide over to the picture a little bit further, yeah, so there's an upper basement level that's below the building right at Matilda and Carroll. That's also going to be renovated. And then if you flip to the next one, there's a solarium structure as well that currently doesn't have any glass in it. And it is going to be occupied by part of that restaurant use. So those are kind of the 3 things we're looking to do. There are no physical changes to the envelope of the building. Because of this use change, it triggered variances that are based on use and gross floor area. So they're transportation related, so parking and loading. BA Group, as in your package, wrote a fairly extensive report looking at the proposed parking supply. There's going to be 14 on-site spaces, and then we also have 37 off-site spaces. They've also looked at the loading. Staff have reviewed it. Transportation Services wrote an email saying they have no objection and are satisfied with what we're proposing to do.
Could you explain to us what is there's a request to legalize here?
Yeah.
And to maintain, could you explain to us, perhaps with reference to the drawings, what we're legalizing?
So all the brick portions of the building predate both bylaws, so they're legal non-conforming. The solarium structure, and there were building permit records that prove that. We couldn't find records of when that solarium structure was constructed. There's been a range of owners over the years, and so the building department took the position that it does not conform with the bylaw, and so they said you only have to get setback variances for that solarium portion of the building. So it's consistent with all the other setbacks. It's actually greater than a lot of the setbacks that exist on site today, but the buildings department said get variances for the solarium structure and we're good.
That's what the legalization element is here, is those setbacks.
Yeah.
Thank you.
Great. I think, we're always, as a committee, always happy to see situations where we're generating more employment, so that's good, office employment. I was struggling with the math, Madam Secretary. I noticed that, just clarification, variance number 1 talks about a minimum of 89 parking spaces, and then variance number 2 on the next page talks about 59.
Different bylaws.
Two different bylaws?
Yeah. So 43886, which is the old City of Toronto bylaw, which is the last variance, requires 59 parking spaces. The new City of Toronto bylaw 569/2013 requires 89 spaces. But it's important to note here that even though that parking rate has actually gone up, it's because it's located in a pocket of known as all other areas of the city. So if it actually was fronted onto Queen Street, which is less than 200 meters away, it would only require 50 parking spaces. So just because of the fact that it doesn't front onto a major street with transit is resulting in this higher parking rate.
Although I noticed that the transit's not far away.
From
both lines.
The number of parking spaces is calculated based on the whole building. The whole building.
Yeah.
That's the rest.
It's the whole building.
That makes the number.
And there's no res here.
No.
Okay. I don't have any more questions, and I think it's a very reasonable request, and the variance is minor, and I like to move approve.
There's a forestry.
That's it?
No.
I thought there was one under Ravine Natural Protection, 50 Carroll. Oh, pardon me, there's not. I beg your pardon.
I'll second that. Yeah.
Okay.
So motion to approve by Ms. Cheng, seconded by Mr. Reid. All those in favor?
Thank you.
Motion is carried and the application is approved. And committee moves to application number 18387 Jane Street. And on this application we have before us plan of survey, site plans, floor plans, elevations, email from community planning, city planning, and a staff report from tree protection and planning review of urban forestry. In support, there are 4 form letters, and in opposition, 1 letter. Good morning.
Morning. My name is Jason Fung. I'm the architect and applicant.
Thank you. Okay, I don't know if we need a presentation on this, but questions from committee members, please. I'll begin. Is this already built?
Yeah, no, so an as-of-right renovation was completed about 2 weeks ago, which, is now complete. It's the ground floor and the basement. What we're looking to do is inject a residential unit on the 3rd floor, and the owner would like to expand her business into the 2nd floor.
Thank you. Okay, if there are no further questions, I'll look to committee for a motion.
Sure, I'd put forward a motion. I think this is a good example of intensifying where it should be in a Main Street context, and adding a floor and expanding a business. I think that's all positive. So I would move to approve, subject to the urban forestry condition number 2.
So I will second that.
Motion to approve, Mr. Reid, seconded Ms. Cheng. All those in favor? Motion is carried. Your application is approved.
Thank you.
Thank you. Committee is now looking at 211 Avenue Road. So are we?
I'm skipping that one.
That is 130.
That was 130. Pardon me again.
20.
Number 20, which is 188 King Edward.
Morning, Mr. Chairman, committers.
Good morning.
Members of the committee, Dan Barry, agent on the application, 39 Victoria Street, Alliston.
Thank you very much. On this application, committee has before it a copy of site plans, survey, floor plans, elevations, email correspondence from community planning, City of Toronto, and staff report from Transportation Services. Okay. Don't think we need a presentation on this one either, but I invite questions by committee members.
Just one comment from transportation. If you're going to make any changes to the existing parking pad, you have to get permission or something.
Correct.
That you will follow that recommendation.
Right.
Yeah, okay.
And on that parking issue, is the intention for 100% paving, or will the?
That is an existing condition, actually.
What's an existing?
That's correct, yes.
Just variance number 3. Size of the deck. Is this a 2nd-story deck?
That is on the 2nd floor.
Okay.
It is, and it's an existing deck.
Ah.
So what's happening through you, Mr. Chair, on this application is items number 1 3, 5, 6, and 7 are all existing legal non-conforming issues that are just being brought to legal through the process here.
They're all legal non-conforming.
That's correct.
Okay.
Items number 2 and 4 are triggered by the proposed addition today.
And that addition is basically a second floor on the front part of the house.
That's correct, over the existing footprint.
I'll just ask a perhaps naive question. The deck on the second story looks fairly big. Is there concern about screening, or is it already screened from neighbors?
It is not screened. As I mentioned, it's an existing condition with just a 42-inch high railing.
Okay.
It's not screened, and there's been no complaints about overlook and privacy, etc.
Okay, thank you.
All right then. If there are no further questions,
I put forward a motion.
Motion?
Yeah, I think given that it's really just filling in the existing footprint and is similar to several houses on the street and in the neighborhood, I would move to approve.
Thank you. Second by, okay. Motion to approve by Mr. Reed, second by Mr. Clay. All those in favor? Motion carried. Application is approved.
Thank you.
Thank you. Okay then. Now, that takes us through the uncontested. And we shall now go back to the start of today's agenda, this morning's agenda, to look at the contested applications, the first of which now is application number 3, 90 Glen Edith Drive. Applicant, please.
Condition? Wow. Oh, thank you.
Thank you. Okay. Would you care to put the site plan up on the overhead, please?
Yes, we can do that, sir. Thank you.
And on this application, committee has before it a copy of plan of survey, site plan, floor plans, and elevations. We have email correspondence from Development Engineering and Construction Services, Toronto. And we have a support form letter signed by the owners of 59 Ardwold Gate. Very good. All right. And so I think on this one, and I'll ask those that are speaking in opposition to this, is that yourselves? And you've come forward. So are there other parties here in opposition? All the parties that are persons of interest who wish to speak to this, if they could all come forward to this desk. Are you speaking in favor of or in opposition to? Opposition. Your opposition to. Please go up to the front desk here. Okay. And so, may I ask your name and address, please?
Thank you, Mr. Chair. Last name is Bronskill, Bronskill, first initial D for David, from Goodman's LLP. We're at 333 Bay Street, Suite 3400. I'm also joined, Mr. Wengel is here, who's the architect on the project, in case there are more technical questions. I'm technically acting as agent for the owner of the property. It's an application for a proposed new 3-story detached dwelling. What I was going to do was very quickly walk through a little bit of history.
Please do that.
Yeah, a little bit of the variances. My understanding is, and obviously I'll let Mr. Harrington speak for his client, my understanding is the main concern from those opposed relates to some trees. I'll do some initial comments on the trees, but then I may have some additional comments for the committee after Mr. Harrington speaks. My client has canvassed in the neighborhood. There is the one.
I beg your pardon, Mr. Harrington. Yes, well, after Mr. Harrington speaks, you'll be confined to rebutting.
Yes,
he may have to say. So you understand that you won't be able to bring up new issues at that point.
I do, sir, and I always want to be careful about presuming to speak for Mr. Harrington. So while I said there are trees, I'll talk a little bit about the trees, but obviously he'll be able to speak for himself, and I will respond to any points he raises at that time.
Thank you.
Thank you, sir. Our client has spoken with many people in the neighborhood. There is the one form letter of support on file. There is a verbal non-objection from other neighbors in the area. There's also an email that was provided to our client of non-objection from another adjacent property owner.
Just one moment, please.
Yes.
Could I ask staff, please, to begin the clock on this? Pardon me. Okay.
Here we go. Thank you, sir.
Thank you.
There is opposition from a directly adjacent neighbor to the west. That property, sir, just on the site plan. Adjacent. It's a rear yard to side yard condition in that area. Our client has worked extensively as well with various city departments. Planning staff asked for some revisions. Those revisions were made and are reflected in the plans that are before the committee and the subject of the public notice. So planning staff did provide an email to us indicating they have no concerns. There's also the ECS memo on file indicating no concerns. And to my knowledge, there is not an urban forestry letter. We will have a permitting process that obviously we will have to go through with urban forestry, but I know they have no concerns, but I don't see them actually recommending any conditions, although we understand there will be a permitting process under the municipal code to deal with the trees. This new design represents an improvement on the street. The existing driveway is actually at the corner. It would sit on the left hand or the east side, north being to the bottom today. It's being moved to the other side at the end of the cul-de-sac, improved, frankly, urban design and safety, taking it away from the corner of the intersection. And overall, we submit it's a nice, lovely design from Mr. Wengel, a high-quality addition to the neighborhood. The variance is being sought, I can group in terms of height, length, depth, front setback, and FSI. If I very quickly on height, planning requested a reduction in height in accordance with the submission and the public notice that has been made. We have in the package, just from a quantitative perspective, it is a smaller neighborhood to go and get examples, but there are some height variances in the immediate vicinity and within the neighborhood. That's just to give an idea of the numbers, but we think the height is appropriate, fits in with the streetscape, and I don't think that is necessarily the subject of concern today. There's a length depth variance, planning staff again support. It's an odd measurement in terms of the lot not being square. As Mr. Wengel is noting for you on the plan, it's measured not sort of parallel with the house, but at an angle from where his pen is. It goes to the back, which is a line perpendicular to the end of the open cabana there that's at the rear, but that's counted as part of the structure. And so that not only is it an oblique measurement for that length depth variance, but it goes to the back of that one-story, frankly, open cabana as part of the measurement. All the other setbacks, other than the front yard, though, are being met, both side yard setbacks and rear yard setback. That one-story open gazebo is still 20.71 meters from the rear property line. And so it's still has an extensive rear yard area. As you'll note, the proposed dwelling is also staggered away from the lots to the west. What happens as the rear goes back, there's additional setbacks before getting to what is that one-story portion at the rear and then the gazebo. And Mr. Wingle, can you just quickly show where the two to the one-story transitions for the committee with your pen? Thank you. So that piece at the back is a one-story, and then there's the gazebo at the back. And frankly, some of the FSI, just because of the function of the lot, we've shown in red an as-of-right envelope. Some of the FSI that might have been deployed at the front just because of the shape of the lot where you've got that triangle, in some respects is just being shifted to the back and deployed in a different way, although in a keeping with the side yard setback requirements. The front yard setback is down at what would be the northeast corner. It basically matches up where the existing building would have a front yard setback. And then because the building moves away from the property line, the front yard setback then increases greatly. I'd submit to you it's a very technical variance. And finally, with FSI, we've again provided a quantitative range of numbers for you. There are some similar numbers approved in the vicinity of the site. I do commend in terms of a site plan drawing that it's a sensitive approach to deployment of the FSI. As I noted to you earlier, it's in keeping with the side yard setbacks, and so it represents, from a qualitative perspective, an appropriate massing on the site. I anticipate the major issues with trees. I would simply note that the trees being proposed, there's 5 of them, for removal closest to the neighbor's property, are in fact unprotected trees. And so I think the trees that are going to be the most significant part of this dispute before you are frankly trees that don't require any permit for removal and can be taken down tomorrow. But that's me anticipating some of the comments that will come. The other significant tree on the neighbor's property, which is a Norway maple, obviously my client cannot injure or remove, and there's no plans to injure or remove it. An appropriate tree protection zone has been set up. So in my respectful submission, I think the trees may be a bit of a red herring, but I'll let my friend speak about them and respond to any comments he may have.
Thank you very much.
Thank you, Mr. Chair.
Then, now we will hear from the person who wishes to speak in opposition, I understand, to the application. Good morning.
Good morning. So my name is Patrick Harrington. I'm a lawyer with Airden Burles. Airden Burles is located at 181 Bay Street in downtown Toronto. I am counsel to the owners of 61 Ardwald Gate. And you have the Google Earth image, the red dot that's shown there is the location of the current application at 90 GLEN EDYTH. And then if you go here, that's my client's home where my pen is. And you will see at the rear of their property, the dividing line between the two sites, quite a bit of green space. And green space is primarily the issue that my clients wish to raise today. What you have in front of you is a very large house with a very large minor variance proposal. You have double the building length, double the building depth, double the FSI, increases in exterior sidewalls, and increases in front and rear main walls. That doesn't mean that this application isn't supportable. As Mr. Bronskill reviewed, there are precedents in the area for pushing the envelope in terms of what the zoning requires. However, in order to have a house of this magnitude immediately adjacent to homeowners like my clients, there needs to be a break in the visual presence of this house, and that's provided by the existing green space on the site. To give you an example of what that green space provides, This is a photograph taken from my client's backyards, and you can see some of the existing green space pretty much screens the visual presence of anything in the lot behind them. The proposal would have a building that would be proposed to be built approximately 1.5 meters away from the property line at a height above the 7.5 meter regulation for main front or for side front walls in that location. One thing I noticed from the applicant's revised materials that they submitted this morning that differs from what was provided in the files that's available online is that their site plan doesn't demark where the tree removals are. You can see a line of trees to the left. You see 4 X's and then 1 X with a circle through it. That is a line of about 5 spruce trees that separate the 2 lots. And then below that, you see a line of about 3 trees with X's through them. Those are, I'm told, are black locusts. Those trees are capable of being preserved if the built form of the building is shifted away from the property boundary or shrunk away from the property boundary in order to provide an appropriate separation and an appropriate length of growing space for those trees to be maintained.
Help me, please. You're interrupting. I'm sorry.
Certainly.
Could you point out where your client's property abuts the subject property?
Let's discuss. My clients would be right about here. You saw the visual of those spruce trees I showed you a moment ago. These are the, in fact,
okay.
Trees.
That's the rear of your client's property.
Precisely.
Thank you.
So the driving force behind the elimination of those trees is obviously the need to build in this area. And so what my client's opposition to this proposal amounts to is a request to move the building away from those trees to try to preserve the natural screening. With that natural mature screening in place, as you saw through the visual, there is an ability to build a much larger and higher house without creating impact on the immediate neighbors. Without that mature screening, and I don't believe there's any proposal to replace those trees, you lose a great deal of the green space, you lose a great deal of the screening. Some of the benefits of moving or shrinking the house would include less impact, better preservation of green space, reduction in the building envelope, and perhaps more in keeping with some of the expectations of the bylaw. But without that change, my clients submit that this does not represent appropriate development of the lot, that the minor variances requested are just too big, and that this application in its current form should be refused, with the direction that the architect can go back to the drawing board and bring something forward that would maintain the screening and hopefully have a better and more appropriate development plan.
Thank you very much. So the impact that you're describing is a visual impact? Primarily, it's a visual impact from their house.
It's primarily a visual impact, certainly the presence of a large structure in that area where no structure currently exists. There's no request for a side yard reduction. They're observing the minimum requirements for side yard, but they are pushing the envelope in terms of building length, building depth, building height, and so the screening becomes an important factor in making sure that a large house like this can be deployed on the site in a manner that is copacetic with the existing residents.
Thank you very much.
Thank you.
So one question. So the variance that mostly offends is the height variance. There's no side yard setback variance, is there?
I would say it's a combination. Because of the way the lot is oriented, you have this larger than normal building depth, building length variance, which is actually what creates the building envelope going back this far into the lot. As well, you have a request to increase the height of the side main walls beyond what the zoning bylaw currently provides for. So those combinations create a need for the screening. And in the absence of maintaining the screening, the proposal just isn't acceptable. With that screening in place, those types of variances, length, depth, and height, are probably acceptable.
Okay. Thank you.
Thank you.
Okay. Opportunity now for the applicant's agent to rebut those points. Specifically, what committee has heard from from Mr. Harrington is that the visual impact is simply too much because of the length, depth, and FSI requests that the visual impact of the proposed house will be very large on the abutting property, and their request is to either move the building away from the lot line, well, it's actually, and to save those trees that are close to the lot line.
I understand. And building on the last question through you, Mr. Chair, just a reminder in terms of the height variance, we're talking about 17 or 18 inches. So I'm not actually sure that a wall of that's 17 or 18 inches taller than is permitted under the zoning bylaw, angled to meet the side yard setback, necessarily has a looming or imposing presence on a neighbor. So I don't accept that what is being proposed in terms of an 18-inch increase to the height is going to cause that type of dramatic impact that needs to be screened. I would respectfully submit this is all about keeping trees. And I would first of all start from where I began. The trees that are closest to the property line are not protected trees. Well, with all due respect, I didn't interrupt your counsel, so it would be kind enough if I could finish with my comments to the committee. Thank you.
The applicant has the floor now for his rebuttal, yes.
Thank you, Mr. Chair.
I'll ask.
I was very deliberate in what I said. The trees closest to the property line do not require permits. I stand by that comment, notwithstanding what was said to me from the neighbors. So those trees can come down. So much of the screening that was shown on the picture from Mr. Harrington is something that, regardless of the variances that are before you, is not actually protected by any bylaw. That's the first point. The second point is the simple proposition, well, just move the wall. Part of the design of this building is premised on moving the driveway to its existing location, to have a one-car garage entrance, and then in fact have a ramp underground that would allow all parking, including visitor parking, to be below grade. It's not that simple to move that wall. It's a request to take the required setback of 1.5 meters and increase it to at least 3, if not more. It would have a cascading impact on what happens below grade. It would effectively mean that the garage could not be located where it's proposed. All in all, in terms of an urban design and parking perspective for this enclave, the ability to provide more parking on site is actually a good thing. So then let's talk about the planting. My clients met with the neighbors who were opposed, proposed a planting plan to them on their property, new trees. They've received no response to that request. No response.
Can you tell us approximately what time frame that was in?
It's been within the last week to 2 weeks.
I have a question on,
Thank you.
On the proposed site plan. On your site plan, there's way like along the border line, you have this green bubble.
Yes.
Is that proposed? Is landscaping or what? Are you proposing to? My question is: are you proposing to remove all the existing plants and redo this all along?
We're showing that as planting along the property line on all property edges. The final plan for that has not been completed. It's these green strips, right, that you're talking about? Yes.
You're planning to replace the existing vegetation.
Yes, and in fact, what we've put up is a replanting plan that includes trees. So just as a reminder for the committee in terms of what is protected on the site in terms of trees, 14 protected trees are being removed, 3 additional dead trees are being removed, 26 protected trees are being preserved. Of the 14 protected trees, 8 are in poor condition. So 6 healthy protected trees are being removed. The balance are all being protected, which includes 26. And what we're proposing is to plant 12 large growing trees from the city's approved list, as well as 18 ornamental trees. So 30 altogether, but in fairness, I don't really count the ornamental trees. I don't think that's quite fair to count. So 12 large growing trees from the city's approved list are proposed for planting. In the end, this is a treed lot. It will remain a treed lot. And in my respectful submission, an appropriate compromise was proposed to the neighbors, given that these trees are not protected adjacent to the property line. for whatever reason that's not acceptable, we're willing to have that conversation and continue having that conversation. That's the appropriate conversation to have, not whether or not these variances should be approved, in my respectful submission. And so I'm happy to take any questions from committee.
Yes, question for you, and just to begin. So the proposal that was made to the neighbor to plant trees, was that to plant substantial trees or seedlings?
This is what was presented. And as part of this, there were also changes made to the west facade in terms of materiality and proposals that every second floor window be frosted to mitigate any privacy concerns. There's been no response from the neighbor directly to our client. That, again, would be the appropriate mechanism for resolution of this issue, not, frankly, what's before this committee.
Mr. Bronskill, I'll ask the obvious question. I appreciate that the offer was made to plant on the opponent's property. Is there, I'm looking at that rendering, is there any opportunity to supplement that with plantings on your client's property as well? I just can't tell from the site plan what exactly is in there. And that it looks like it's that little strip here that is of some concern.
Yeah, sort of roughly where Mr. Wengel's pen is. And there is a proposal now to have one, the green tree there that's being shown. Ornamental tree to be planted. The concern in the side yard setback space, frankly, is having sufficient soil depth to get large growing trees. It's something we can explore. Just given where the underground is against the 1.5, I don't know that a large growing tree can necessarily be planted on our client's property. I think that was part of the idea of proposing it to the owners, to the adjacent. They would then be able to have those trees on their property, frankly, own those trees and be in control of them, and not have them cut down unless they chose to do so or chose to seek a permit.
I don't know how rebuttal works, but you mentioned that the neighbors adjacent haven't responded. I wonder if the committee would benefit from hearing a response on that proposal.
I think that's in order, yes.
We'd be happy to hear from the owners as to why it's unacceptable.
Okay, then I'll ask then Mr. Harrington to return to the podium, please, to address this question. Okay, so the question for you is that there is a proposal apparently that was made, and what is your client's opinion on that?
Yes, the proposal was made essentially that if you want screening, put it on your own side of the property line. Our building's not moving, our building's not changing. So the entirety of discussions between Mr. Bronskill's client and my client has started with the proposition that this building is already built, it is not changing, it is not capable of change. There is obviously, as Mr. Bronskill set out, a proposal for a ramp to an underground garage, which is a major driving force behind their inability to have any wiggle room on this side of the property. And so their proposed solution is, instead of the tree cover you see there, to provide what my clients would consider to be appropriate natural screening, we have the more ornamental proposal that requires pieces of my client's yard to be dedicated to screening their proposal. That's not acceptable to my client. They would prefer that they screen their own building if they want to put it that far back in the property at that height with an underground garage. Create the space to create that setup on your side of the property, and you probably have a deal.
Further questions? Mr. Harrington? Anyone? No? Thank you. All right.
And And sir, that's helpful. There is a small factual inaccuracy in there. Changes were made to the building and proposed as part of this. First of all, in response to planning. Second of all, in response to direct requests from the neighbor about privacy, about the chimney, and about the materiality. So changes were made to the building to attempt to address some of the concerns. I think the fundamental ask from the neighbor is to preserve unprotected trees. And I don't think that's a reasonable ask, and I don't think it's tied to the variances. In an effort to try and find common ground and mitigate that concern, our client has proposed a planting plan. They remain standing by that proposal. But otherwise, the screening that Mr. Harrington keeps showing you as of tomorrow, there is no legal right for it to exist. Even today, as I stand in front of you, there's no legal right for that screening to exist. And that's not an implied threat. I'm not suggesting that I have a chainsaw in the trunk of my car parked at my office and I'm going to be driving up to Ardwald Gate and as a lawyer cutting down unprotected trees. It's the premise upon which the submission is being made to you that should be questioned. They're not protected trees. They're on my client's property. They can take them down irrespective of what happens during this process. And so I just respectfully say to the committee, that's not therefore tied to the variances being sought before you and should be irrelevant to your considerations.
Thank you very much.
Thank you, sir.
Just a moment, please. Any further questions?
Just one small question on your new material, the new site plan here. The green dotted line, is it the existing building? The green dotted line.
Yes, the green dotted line is the existing building, through you, Mr. Chair.
The existing setback is actually smaller.
Yes, the existing building does not comply with the west setback. We're actually putting the west wall further away from the property line than exists today. Thank you, Mr. Chair. Thank you, committee.
Thank you. Yeah, thank you.
Okay, then. Thank you very much, speakers. At this stage, then, the committee will take the application into committee.
Okay. I'll just start. I'm not as concerned, frankly, about the proposed variances. I'm sympathetic to the point that the height variance is only a foot or 18 inches higher than approved. There doesn't seem to be any concerns. I mean, notwithstanding the general observation from the opponent that it's large, but what I did hear was that if there could be screening, they'd be happy with the size. So I'm not convinced that the size overall is out of character with this neighborhood. I am interested in pursuing the issue of screening, planting, and not just as the proponents suggest on the opponent's side of the line, but I did hear the proponent say that there was a willingness to consider, the technical ability to do plantings on the proponent's side, and I think that's something that the committee should, if the committee agrees that this is a reasonable proposal, that would be an avenue that we should consider pursuing with both parties.
Do you suggest have soft planting as?
I'm suggesting, that the offer to do plantings on the opponent's side should stand, and whether the opponent chooses to accept that or not is up to them. But I'd also say that I heard council suggest that plantings on their side, on that narrow strip, while may be difficult, may not be impossible. And that there would be perhaps an opportunity to pursue some innovative way to introduce screenings on their side of the property as a supplement to the offer to put screenings in on the opponent's side. It just seems to me that I wouldn't want to leave that path unexplored in a real way rather than an artificial way. I think if we can somehow, if again the committee thinks that this is a good proposal, how can we ensure that the proponent pursues that possibility with some passion?
Okay, the issue is that committee is dealing with the application that's before us and the minor variances that are that are before us. Something like an arrangement whereby trees were to be planted on the other side of the fence. That would be a side deal between the.
I totally agree, and I don't know whether we can even do that.
Yeah, but on the other hand, though, they're seeking they're seeking variances. For example, increasing the floor space index like 200 times more than twice. So in return, they get all these variances, and also the depth of the building is like more than 6 meters. It's they ask for a lot too.
But I am convinced by the opponents. What sounds like they'd be okay if they can screen it better. That's what I'm hearing, and I appreciate that the proposal from the proponent to the client to plant on the opponent's side is unsatisfactory. I think I wonder if buttressing that with something in addition to that, which I don't know whether we can even put a condition. Always, I'm saying we can't put a condition in.
Let's ask staff.
Yeah, through you, Mr. Chair, it becomes an issue of enforcement when it's on private property. So who would enforce that those trees or the screening is planted appropriately and that it is maintained?
Right. No, I get that. It always comes down to policing and enforcement. But I
think the trees that they are, I don't know, maybe Mr. Bronskill can clarify, but the additional trees that they're going to be planting on the property, is that going to be overseen by urban forestry, or are you just doing that on your own? Yeah. Please
come back.
That's being proposed on our own. There is a permitting process through urban forestry where they will require us for the trees that are the healthy protected trees that are being removed. We will require permits. There may be a replanting requirement as part of that, so they may be the two of them together.
Right.
So can I go to committee to ask him a question?
Sure.
Yes, you may.
Ms. Brown, I just want to, I'm not even sure whether the opponents would agree to this, but I do want to explore what I thought I heard you say, that you would investigate whether, in fact, you can put screening on your side of the property.
Yes.
Is that true?
It is something we're prepared to investigate, yes.
Okay.
Through you, Mr. Chair, if it's any consolation, there is the 20-day appeal period, at which point, if they want to negotiate within those 20 days, they can come to that agreement, and hopefully it will avoid an appeal to TLAB.
I know these are recorded, and I do have instructions from my client that until the appeal period, we would be happy to continue those discussions and try and resolve through a private agreement on an appropriate preservation plan and avoid a TLAB appeal. I will say, at the risk of being, this is a bit of the chainsaw threat, I guess, that's easier for me to do if I don't have to file an appeal. So I hope the committee understands what I mean by that. It's hard for me to negotiate a tree planting plan before the appeal deadline if I have to appeal the committee's decision to get the approval. It's easier for me to negotiate the tree planting plan if I'm trying to avoid an approval of a positive committee decision. It's just in terms of how that would work. Thank you, Mr. Chair.
All right, then. Further comments in committee? Ms. Chang? Mr. Reid? No. Okay, then, at this point, then, I am looking to committee for a motion on this application, please.
So, Mr. Chair, I will move a motion. I'm, for all the reasons we talked about in committee, I appreciate it is a large home, but it's not a large home in the context of what I think the neighborhood currently looks like and feels like. am sympathetic to the concerns, and I think, you know, maybe what we can do is try and attach some conditions, and I appreciate that technically that's not necessarily the best way to do it, but I'd like to at least try doing that anyways. And so I do think the variance, particularly on the height, is modest, again, particularly given the neighborhood. I would move a motion to approve the variances subject to a condition such that it is that efforts between the client and the opponent continue to negotiate a satisfactory resolution, including the offer from the proponent to install appropriate screening trees on the opponent's property, and to also install appropriate screening on the client's property in the area in question. And I know
I have no one to enforce that.
I know, but I'm putting it in anyways.
Okay, so your recommendation.
That's my motion.
Yeah,
Your
that's
condition
a
is.
good record. Yeah, that's
Through you, Mr. Chair, perhaps an easier way of doing it was we can add it as a for the record comment by the committee that you acknowledge that the applicant was willing to continue to work with the neighbors regarding screening on the shared mutual property line.
You consider that as a
I mean, I appreciate.
It doesn't really have any teeth. The city's not going
I
to be
understand.
enforcing that, but it's just an acknowledgement in the public record that there was a committee.
Well, I will appeal to both councils to also to pursue that course of action over the next 20 days, but I agree with that as a stipulation.
Okay. So in that case, no, in this case, at this point, we have a motion by Mr. Clay to approve with a for the record comment that the applicant and neighbor continue to discuss viability of planting screening trees on one side or the other.
Or both.
Or both. Well,
I think that's my real point is that, you know, there's an opportunity, I think, to do it on both sides.
Okay. So the for the record comment then is that the parties continue to explore screening tree planting on both sides of the property. That is as a for the record comment attached to the approval. Is there a second for that motion? Second by Mr. Reed. All those in favor? So the application or the motion is carried such that the application is approved with a for the record comment that screening tree planting to be explored going on by the parties. Thank you very much. Okay, we'll move on now to the next held item.
that's the but then we still have to express it as
Yeah, I get it. Yeah. We can't send out the tree.
And the next held item is number 6, 431 Concord Avenue.
tree or bush.
Good morning.
Good morning.
And just a moment, please. Good morning. Okay, on number 6, the committee has before it the following materials. Copy, survey site plan, floor plans, elevations. Email from Community Planning, City Planning Toronto. In support, 1 signature petition signed by occupants of 434 Concord. And in opposition, correspondence from Sarah Barker and Walter Brooker, Anna and Kevin Sorokin, and Jahan Babi, all of Concord Avenue. And In particular, Anna and Kevin Sorokin are next door to 431. Good morning. May I ask your name and address, please?
Sure. My name is David Riley. I'm a planner with SGL Planning. The address is 1547 Bloor Street West.
Thank you. Just a moment, please. May I ask the people here at this desk, are you here to speak in interest on this? And how many of you wish to speak? Other persons wishing to speak? Show of hands, please. So there are two speakers. Two speakers, okay. Three speakers. Two speakers, okay. Two speakers to follow. Very good. Please continue your presentation.
Thank you very much. This is a proposal for a third-story addition. There's an existing two-story dwelling here. This is a semi-detached dwelling. The third story is proposed to accommodate an additional secondary suite. Currently, there are three legal units, so 2 secondary suites in this building. However, it's my understanding that there are actually 4 units within the building today. So the proposal is for a basement unit, a first floor unit, a second floor unit, and a third floor unit, as shown on the plan. So 1 dwelling unit on each floor, which is the number 3 secondary suites. So the dwelling unit plus 3 secondary suites. The third story addition is to be built over the existing footprint of the building, and it's actually stepped back by 1.3 meters at the rear. So the third story is entirely above the existing footprint. There's also a balcony on the second floor that's proposed at the back, as well as a balcony on the third floor. The balcony on the second floor will be above the staircase that you see at the top of the screen there. And the balcony on the third floor will be on the portion of the roof above the second floor. So just wanted to clarify that with respect to the balconies, there are no variances, but the addition of the third story generates a number of variances, as well as some changes to the interior and the front of the building. The main variance is the floor space index, which is an increase to 1.18. There's also variances related to permitting a secondary suite where changes are being made to the front main wall. And then with respect to the additional secondary suite, there's also a parking variance required. So 3 parking spaces are required. We're going down to 1, which is the existing parking space on the property. And then a change is being made to the access to the basement unit. So a variance is required for the front staircase. There's an existing front staircase that leads to the basement unit. However, it's being reconfigured, and there's a variance with respect to how close the stairs can get to the property line. I was retained by my client to be here kind of very short notice, unfortunately I wasn't able to prepare a letter because it's a bit last minute, and the applicant was not able to, is out of the country currently. But when I was first approached at this, I have to satisfy myself that I can support this as a planner. And what stuck out at me, of course, was the 1.18 FSI at first, and I thought, wow, that's almost double the existing permitted FSI of 0.6. So I looked into, of course, can I support this? With respect to the existing FSI on the building, that's 0.8. So the existing FSI of the existing building, the 2 stories, is 0.8. The addition of the third story results in the additional square footage, which brings us to 1.18. As you can see on the plan, as I noted, it's being built entirely within the existing footprint and stepped back from the rear of the building. There appear to be, when I was walking along the street, many homes along Concord that do have a third floor, Albeit the third floor, what I noticed is within a roof line. So that's one of the differences with this. The front wall would actually be a very apparent third floor addition, which might not be as apparent on other properties. But with respect to FSI, it struck me that likely many of the properties along Concord and within this neighborhood might have higher FSIs. I did an analysis of past Committee of Adjustment decisions and noted that there is a range of FSIs, including on Concord, along Ossington, along Dovercourt, within a 500-meter radius. And this does fall within a range of approved FSIs in the neighborhood. So I satisfied myself that this is something that I could support as long as it's designed to mitigate impacts on neighbors. So one of the impacts that I always think about is overlook and privacy. And on the third floor, or I guess when you're getting building depth extensions,
you have about half a minute to go.
I'll be very quick. Anyways, in my opinion, this proposal doesn't generate any adverse impacts because of the step back, and we're not extending the depth, and it matches the depth of adjacent buildings pretty much. That third story is brought back to match more or less the depth of the second story portion of the building to the south. With respect to parking, this is very close to Ossington subway station. You can see on this map, this is a 500-meter radius around Ossington subway station, and we're within that kind of 5-minute walk. I think this is a really good area to provide for additional secondary suites, additional units, intensification in a way that's permitted. Singles and semis are allowed to have more than one secondary suite. So the variances are related really to the form and the space. So I do think this is appropriate. And quickly, with respect to the there's a variances under the old bylaw with respect to the side yard setback, essentially saying that you need a setback, but the setback proposed is 0, of course, because this is a semi-detached dwelling. So that's where that comes into play.
Thank you. Okay then, I'll ask the applicant to have a seat while the first speaker in opposition speaks. Good morning.
Good morning. My name is Anna Sorokin, and I'm here with my husband, Kevin Sorokin.
Yes.
We own and reside in 433 Concord Avenue, which is the property attached to 431 Concord Avenue with our 2 young children.
Yes.
So we're here to ask that you reject this application to construct this full 3rd-story addition and legalize these 4 units.
Tell us about your concerns, please.
So we purchased our house in 2013, and at that time we did our due diligence before we purchased our house. We understood that there were 3 units in the home. We went ahead with purchasing our home, and we gutted and renovated our whole house to make it into our forever home. We moved in 2014, and since then have started a family. But not long after that, we found that the house actually contained 4 units already in this 2-story home. So there's 1 unit on the 1st floor, 1 on the 2nd floor, and 2 in the basement. So we've had a decent relationship with the property manager. We've never met the owners of the house, and we're surprised to find out through the notice for this hearing what they were proposing. Nobody gave us any notice, including 429. Nobody told them either. Even after they asked the surveyors and the property manager what was going on, there was nothing. So legal or not, they already have 4 units on the site, and if they are allowed another unit, we can only imagine what is coming. Currently, as a semi-detached home, they are allowed 2 units, but he said they have 3 legal units. Allowing the construction of a 4th unit will mean that they are increasing the unit size by 100%, which to us is very excessive. This is excessive and clear overdevelopment of the site. We understand that this is a business venture for the owner, and they are out to maximize their profits, but this proposal is clearly excessive. We would be okay with them gutting the home and creating 3 legal units within the current envelope of the building. When we purchased our forever home, we did not sign up to be attached to an apartment building, which is essentially what they are requesting that they turn this semi-detached house into. We could see this proposal maybe working on a detached home, but not in a semi-detached home like they have. There are currently no homes on our street where a semi-detached house has been allowed to be turned into a full 3-story detached home. He mentioned the precedents. We are not Ossington. We are not Dovercourt. Those are major streets with bus service. This is Concord, a small, family-friendly neighborhood. About 3 years ago, the house at 435 Concord, which is on the other side of us, was proposing essentially the same thing. However, at the time, city planning was very concerned with the FSI being proposed, which is similar to this one, and the applicant decided not to go forward with the third-story addition. So the fact that city planning is staying signed on this file shows that the density creep is happening, and it's greatly concerning for us and our neighbors on the street. This area is designated as neighborhoods in the Toronto official plan, which does not allow for gross intensification like this being requested here. This application therefore does not meet the general intent of the official plan. If this is allowed on this site, there is no telling what precedent will mean and what will be allowed on the street 5 years from now. Another of the major concerns that we have is that the front wall is being proposed to be moved forward, allowing for a full third-story addition. This does not fit in with what is currently seen in the neighborhood. We and many of our neighbors are concerned if this is allowed, it will open the gates for other houses to do the same. Most of the variances are not minor, but this one especially will change the face of the neighborhood. In addition to this, we are personally concerned about the effect that disturbing the structure will have on our property. Our 3-year-old's bedroom is located on the front of the house and her ceiling is pitched. The applicant is looking to tear down the pitch, so if anything happens, the party wall, which is as thin as a regular wall inside your house, could damage the structure of my home. When we were doing our renovation, we were advised by our structural engineer not to touch the shared chimney, as there was a chance that it could alter the structural integrity of the front of the house. We therefore did not touch it inside or out. On the plans, it looks like the chimney has been removed. If not, they are not showing how they plan to address this matter.
I'll just advise you that you have less than a minute now to wrap up.
In addition to the construction of the full of the third story, we are concerned about the deck. We understand that there's no variance for the deck on the second story. The third story, there's also no deck variance, but it will. But if you allow the third story, you will allow a third story deck. Lastly, if the allowed proposed changes would significantly affect our quality of life. In addition to the backyard concerns, we're also concerned about increased noise. Currently, we cannot keep track of how many people live in the units because they're always coming and going, but we do know that the sheer amount of people living there create a lot of noise. Should a third-story unit be allowed, especially with the staircase attached to our party wall, the noise and vibrations will only increase. We also have skylights on the roof of our house, one as close as almost about 3 to 4 feet, which will be totally blocked by the new addition.
Thank you for your presentation.
We appreciate your concerns, and we hope you take this into consideration. Thank you.
Just hold on a moment, please. Thank you for your presentation. And are there any questions of the speaker from committee members? I have one to begin with. I'm trying to get this straight now because I think I've heard 2 separate figures. Is it your understanding that this proposed development will result in a structure with 4 units or 5 units? 4
units. There are 4 kitchens, but but right now there are currently 4 units already. And I understand that in the plans they are showing 4 units.
Right.
I believe that they have the resources to keep that basement in
Pardon me?
Story unit.
I just want to say there's also 2 separate basement
entrances.
So that's currently it's used. There's one in the back, one in the front, and those are the entrances to the 2 basement units.
Okay.
And that's still continuing in the new plans. So I don't see any reason why they would continue to not have 2 units.
Even if
because again, the number one force for the owner from our experience and the neighbors' experiences.
Thank you very much. Okay. And and if I could ask you this, the impact then on you of this proposal on your property, enjoyment of your property is what?
We are very concerned about the density. This is way too much happening on a single family detached home. We didn't sign up to be living next to an apartment building, which is what they are essentially proposing. There are so many people. There are 4 kitchens in this site. I mean, I guess they would have to do some kind of fire rating while they're doing that, but we don't trust that they're going to be maintaining these units properly because they haven't been doing it for at least the time that we've been there and much longer from what I gather from the other neighbors.
Okay, thank you very much.
Thank you
for your presentation. And there's another speaker to speak now. Please come forward.
Hi there. So my name is Lena Dos Santos. I'm speaking on behalf of 429 homeowners that are sitting right there. I will try not to repeat what she's already mentioned in the interest of time. So they've been homeowners for 42 years, 43 years actually this year. So we've seen a lot with this homeowner. He's been there for more than 20 years. So some of the concerns that she has shared, which is that there are 4 units in there. So when they started their last renovation, which was about 15 to 20 years ago, they actually proposed a 3-unit basement, main floor, second floor dwelling. And over time, they added in that second unit, completely illegal, in the basement. So with that said, there's really no need. There's 8 people living in that house right now. There's no need for them to increase with a 3rd floor. The concern I think we all have is that really with that added floor, who knows if they've already added in a basement illegally, who knows what they might do with the other floors. That's the main concern. So the other concern we have with our own property is that when they did their renovation 20 years ago, they actually took the pathway in between our 2 houses and they excavated it just so that they could give their basement windows. That exposed our foundation. They never asked for permission. They never sought any permission with the city, with us, nothing. They just did it. So we are concerned that with any construction that happens, that might affect our foundation. That might lead to flooding, and then they have to fit the bill to fix that. And on top of that, we are always hearing noise back and forth through that pathway. That's a given for the past 15 years. Because it's used, as she mentioned, there is an entrance at the back, so they always have to walk through. With that said, I don't believe he mentioned it on the plans, but he did mention 2 balconies, 2nd floor and 3rd floor. But I believe on the plans it also says main floor veranda at the back because there's a reconstruction of the entrance to the building. They're also adding a main floor veranda. So that's 3 people or 3 dwellers who will then overlook into our property. So that's a huge privacy issue for us. My mom spends a ton of time out in the back gardening. They also have grandkids that come over and enjoy that space. So that's a lack of privacy that we'll be facing with this situation. In terms of privacy, we'll also have a situation in the front of the house. Because our house is pushed back, there's also a proposition for the 3rd floor window to be facing our house. So anyone who peeks out of that window will be able to look into our house. So we are really facing privacy from every which way. The other thing I'll mention that wasn't mentioned is maybe the upkeep. This is obviously an apartment-styled home that they're trying to build, and over the past 10, 15 years, lack of maintenance on this building is a real problem. And maybe that's our fault for never bringing that forward, but my mom and other neighbors constantly, especially during the summer, put out the garbage for that house, because if we don't, it just sits there for weeks. The property manager or the homeowner, they don't come over to check in on that.
Okay, just for a moment, remember that bylaw enforcement is not handled by the Street Committee of Adjustment.
Fair enough.
Nor are construction issues.
Fair enough.
Just so you know, please
Fair enough. I just want to get that out because that is an issue in terms of adding that 3rd floor. That means that there's somebody else going to be living there. So I just wanted to put that out, but fair enough. I believe, just because I don't want to repeat anything that they've said, I believe we're covering everything. I'll leave it at that. I don't want to repeat, but I will ask, our letter didn't get to your table, so if you don't mind, can we submit that?
You may submit it today, and we'll take it, add it to the materials. Thank you. And please remain at the microphone for a moment. I'd like to see if any of my fellow committee members have questions for you. I have one to begin with, and then I'll open to them. You were mentioning the overlook issue.
Yep.
The primary overlook issue is on the side, not at the rear. It's the side overlook. Is that?
There's 2. So there's at the back. So once they build the balconies, their house is already built almost past ours. So those balconies will actually exceed our line at the back. So they'll have direct vision right into our backyard. All 3 floors will have direct vision.
Okay.
And then I had mentioned the issue at the front with the window on the 3rd floor being proposed. Because we are pushed back, they'll be able to see into our house.
This one.
Okay. Yeah, thank you. Okay, now I understand. Okay. And just on the number of units, issue again. Can you give us a sense of what the impact of the number of units is on your enjoyment of your property?
Well, currently they've got 4 units, so that's quite a lot of people traveling in between. But what they're proposing in terms of construction is the main concern would be our foundation that's exposed. Because of all of the build at the back, they really exposed our foundation at the back. So we're concerned about flooding or any other issues that may lead to cracks that we might have to fix. So that's something that's a big deal for us.
Thank you very much. Just again, those are construction issues that again committee deals with the minor variance requests that are before us. But thank you. Okay.
So just to be clear, so I'm looking straight on at the proposal. Your parents' house is the one, if I'm looking straight on to the right?
If you're looking straight on, yes.
To the right.
Yep. Okay. It's the south of the house.
Yours is not attached, but yours is attached.
Theirs are attached.
Okay.
Yeah.
I got it. I got it. Yeah.
Okay.
Very good. Thank you for your presentation.
Thank you for your time.
I'll ask the applicant to return now with rebuttal. And just to recap the comments we've heard from neighbors, there is a level of concern by both neighbors about the number of units. How many units is this proposal? How many does it actually involve next door? And also the overlook impacts of the 3rd floor with windows facing into their backyard. So if you could address those issues, please, for committee.
Sure. I think I'll start with the overlook issue just because I threw up this plan here. So this is an elevation of the south side, so it's a south elevation. So 429 would be adjacent to this. As the owner just mentioned, 429 is set back beyond the face of subject property. You can see that on site. So this is 429 right here. You can see that the front wall is set back. What I wanted to show was that with respect to the first window that would be constructed, it's actually fairly in line and actually slightly behind where that front wall is of 429. So in terms of overlook towards the front yard, in my opinion, there is no overlook issue. With respect to the rear, you can see on the site plan that I noted earlier that the 3rd story is actually stepped back from the rear of the dwelling of the adjacent property to the north and is in line with this 2-story portion of 429 to the south, and they have a 1-story portion extending further beyond the rear wall of the house. And I wanted to note that on the elevations, it's noted that there are privacy screens proposed for the 3rd story and 2nd story decks. So
privacy screens are 1.8 meters?
I believe it's 1.5.
Yeah, it's 1.5.
1.5 probably do it, yeah. Okay. All right, thank you.
They're listed at 1.5. Okay. I don't imagine 1.8 would be an issue if that was something the committee would be interested in. With respect to the units, as I mentioned in my presentation, it's my understanding that there are 4 units existing and that the proposal would, again, have a total of 4 units, except that the 2 units that are existing in the basement, which to my understanding are not legal, and to my understanding only 3 units are legal within the existing structure. Although there are 4 units now, the proposed additional unit on the third floor that's where the additional unit would be, and then extensive interior renovations to the entire structure, including the basement, because all the stairs are being moved. Essentially, it's a total renovation, and it'll be 1 unit per floor. The city's building department would have to satisfy themselves that is the case before signing off on the building permit.
Is this occupied by the owner, one of the units?
I don't believe so, no.
So certainly the submitted basement floor plan shows 1 washroom, 1 kitchen, and it appears to be a large 1 unit, maybe a 2-bedroom. I see 1 bedroom. So the basement appears to be one unit in the proposed configuration.
Exactly, yes.
And having two doors is a good thing because that allows egress in the fire.
Yes, and as was mentioned, there are existing 2 doors right now, one at the front, one at the rear. The construction of the entrances to both of those basement entrances, the stairs are going to be reconstructed through this because they're not, I'm not a structural engineer, but in my opinion, they don't exactly look like the safest staircases today.
Other questions?
No. You mentioned in passing that this site is about 500 meters from Ossington subway.
Yes.
That's a really important figure in planning terms.
Yes, absolutely.
When you say about, I mean, that's typically about a 10-minute walk. Have you actually, oh, you see you've done this.
So this is a 500 meter. In my experience, the 450 meter is really a 5-minute walk from a subway station. 900 meters to 1,000 meters, they say, is about a 10-minute walk. But within a 500 meter circle is the subject site's indicated with a star. I did a Google analysis if I was walking from the building to the entrance to the subway station, and it came up as 450 meters exactly. So we're within that 500 meter walk, and as you indicated, that figure from a major transit station in terms of providing for more density, these are the areas where I think, particularly within neighborhoods where you have secondary suites or multiple secondary suites permitted within single and semi-detached dwellings. I'm not sure if this was in the bylaw before, but the new, I think it was bylaw 549 2019, which came into effect this summer, which is where this comes from. Essentially, you're allowed to have more than one. And that's kind of bringing it in line with provincial policy to say that you can have intensification within these areas, and I think this is a good way to provide for sensitive intensification within an established neighborhood.
Well, to be fair, that 500 meter radius requires delineation by the city before. It's not always just a simple circle.
Absolutely, yes.
I don't think the city's delineated this area just yet.
No, I would agree with you. I haven't seen that.
Right.
And I had prepared this figure really as a justification for the parking reduction, where I think that with being so close to the transit station, I think it's appropriate to consider parking reductions in these areas. And I have reviewed some committee of adjustment decisions within the neighborhood that have reduced to 1 and 0 parking spots.
I have, we're in committee now.
Okay, so at this stage we will take the application into committee. I assume there are no further questions of the applicant. So.
I just want to express my thoughts first, and then whether they're going to get supported or not. My opinion, my understanding of the intent of the bylaw for multiple second units, I have a lot of sympathy to say adding rental units in a city, in the center of the city. But that particular variance number 3, that it said that you can add it if you do not change the so-called the elevation or the building fronting the street, which in this particular case, I cannot support the proposal only because I think it's a semi-attached and it does create a tremendous impact on that particular situation. If it's a detached house, I will support it. That's what I am thinking. And because you're not asking only to maximize the number of secondary units, you actually, in order to do that, you actually have to add another floor to it. So in my opinion, is overdeveloped, and I cannot support this proposal. That's my standpoint. I don't know. I want to hear other people.
So I'll just weigh in a little bit because I can. I too am sympathetic. When if you think about city building and the need for providing accommodation for people within walking distance of major transit, I think that's a laudable goal, and we should all be supporting it. Having said that, I am quite sympathetic to existing owners of a semi-detached and the impact on them of having 4 rental units in the adjoining building. I do think that is, we don't have a definition for it, but I would suggest that that's a hardship, in my view, and unnecessary hardship. And notwithstanding the next door neighbors, those aren't issues necessarily that we can deal with. But I am sympathetic to the view about adding density intensification on one half of a semi-detached where the owner isn't resident. And while I totally support more rental accommodation in the city, and particularly in these kinds of neighborhoods, I'm of the view that the impact on the adjoining semi-detached home is a little excessive, and similarly, I don't think I can support this application.
In that case, can we move to a motion from any committee member?
I'll move a motion for the reasons we discussed to deny this application.
Motion to refuse by Mr. Clay, seconded by Ms. Cheng. All those in favor? Those opposed?
Yeah.
Mr. Breed opposed.
Thank you.
Your application, sir, is refused. We move on to application number 10, 603 Carlaw Avenue. And on this application, committee has before it the following communications: copied plan survey, site plan, floor plan elevations, 3 renderings of the property, correspondence from Stephanie LeBlanc, agent, and from commenting agencies, there's a staff report from community planning, and also from tree protection and plan review of urban forestry. So good morning to you. May I ask you to state your name and address, please?
Good morning. My name is Stéphane Leblanc. I'm the applicant for the project from Stéphane Leblanc Architects. We are, this lot, we're proposing to demolish an existing building built on the lot.
For you, Mr. Chair, are there other people here that are opposed?
Pardon me.
Is it just this gentleman here?
Just a moment, please. All those wishing who are here in interest in opposition, please have a seat along this side. And let's just determine how many speakers wish to speak.
May not be required. So
okay. We've met outside and come to an agreement, so I can speak about that, and if they want to kind of speak.
Carry on, please.
So we're looking to demolish an existing single-family dwelling and to build a new one on the same lot. The existing building that we're demolishing was initially built as a secondary house to the property to the north. It was part of the larger estate. So the owners in the 1960s took a garage and turned it into a house. That existing building now is set all the way back to the property, and that's some of the changes we're looking to do is to address that. Also, because of that condition of being a severed lot, the existing house, the existing lot that we have doesn't have a very deep backyard. So what we're proposing to do is to build a new house, bring it forward on the property so that it lines up with the neighbors to the south and kind of respects that street wall, and to the rear brings the back wall close to the neighbors to the south again, keeping that idea of maintaining that rhythm on the street on Carlaw. The minor variances we're requesting have to do with FSI. Because of the small lot, we don't have much FSI as of right, so we're asking for slightly larger than that. We don't think there are significant precedents on the street that we think allow for that. We're looking to have a rear yard setback minor variance and a rear deck minor variance. Again, because of the narrowness or the shallowness of the lot, it's hard to build a house of a significant or sort of reasonable depth with that setback as it is. So we're asking to go a little bit further into the backyard than allowed by the bylaw. We are also looking to change to modify some of the main sidewall heights, essentially because we want to kind of maintain on the front the size where the master bedroom is. We want to kind of maintain the full 10 meters on that one corner. There is also a request for the driveway, which I'll speak to later. The one thing I want to discuss is we've spoken to the owners of 5 Roxeter and 7 Roxeter, which are the houses at the at the street that's kind of perpendicular and whose backyards our house currently overlooks and would overlook. By removing the existing house, which is essentially a two-story brick wall for them, we're creating an issue of overlook and we're removing some of their privacy. So that was essentially their concerns. We've met with them. We've come to a series of solutions that we think will be amenable to everybody. So I'd like to, if possible, either enter them as conditions or as for the record. Is that?
Mr. Chair, I don't want to get into the habit of putting everybody's private agreements in for the records, but do any of the conditions affect the variances?
No, the conditions don't affect the variances. They are essentially issues to deal with privacy and overlooked. So they're building code issues and building construction issues. Yeah.
So just for the neighbors, in case you want to change your thought on whether or not you wish to speak, the committee is dealing with the variances that are before us. So a side agreement between parties is fine and good, but it would be dealt with by the parties themselves. It's not part of the Committee of Adjustments decision.
Okay.
So if that changes your decision or your thought about speaking, then you may speak if you wish.
Yeah, if you could describe what the
so by having what essentially we have a small walkout deck and a stair. Our main level is essentially what's the second floor. It's lower than the standard second floor, but because of the conditions of the house, we've raised it up a little higher than the typical house around the area. We have a walkout deck and stairs that come down to the backyard to access the backyard from that main floor. The concern with the neighbors is that deck provides a balcony and a platform that overlooks their yard. So one of the agreements we came up with is we would reduce the size of that deck and provide a visual screen that would remove that concern. We've also talked about reducing the amount of windows area on the back of the house and frosting some of those windows. And also to address some of the concerns of the neighbor at 5 Roxeter, we had done some initial shadow studies. We're going to pursue some more specific shadow studies that deal with her side windows. So because of the height of the house, she was concerned, and where we're locating it, she's concerned about the additional shadows being cast into her windows on the side of their house.
So the deck involved that you're prepared to reduce in size, that deck is not the subject of a variance, is it?
The extension into the rear yard is a minor variance. We're going further into the rear yard than what we...
Oh, okay.
Mr. Chair, if we can actually get a square meter figure for how small the deck will be, and then you can impose the condition for screening. I just need to know on which sides the screening will go.
The screening will go on the east side of the deck, so on the rear, facing the rear lot line.
And then the size and deck?
And I don't at the moment have an area for the reduction of the deck.
Could you work one out? Take a minute to work one out?
Yeah. We could reduce it to 3 square meters.
3 square meters.
Yeah.
This 820.
That's the second floor deck.
Yeah.
And again, I'm asking, is that the subject of a variance or not?
Yeah, it's
which variance number is it?
It's variance number 5, a platform without main walls attached to.
Pardon me.
Yeah.
Very good. Okay. Okay.
And there's one more issue I'd like to discuss, which has to do with the planner's report. Yeah.
So when we get that down to 3 meters squared, does it still require a variance, or have we removed that variance? Let's just check that out.
I don't think there's a
you cannot, yes, like 1 meter and more than 1.6 meter.
At this point, we would still require the minor variance because of the depth that it goes into. We would reduce the width, which is not...
So we will cite the proposed area of the deck at 3 meters square.
Okay.
Attached to the variance number 5. Yeah.
And then the other issue I wanted to address was the planner's report is recommending to refuse the minor variance for the driveway width. We're allowed 3.66 meters for a driveway width, which corresponds to the width of the garage and behind the main wall of the building. We're asking for 3.89 meters, so we're asking for 23 centimeters extra. The reason for that is we want to combine the driveway with the sort of space to the access, the walkway, and we want to kind of have it all in as one paver, so there's a consistency and visually it's minimized. It's also going to allow us to kind of take over less square footage on the front yard. So we're providing 51% green space or permeable space to the front lawn, which is a little bit beyond what's currently required. And we want to include the walkway into the driveway, which is why the driveway is 3.89 meters. Part of that is actually considered safe walking space to access the front door.
Is that for the, would you need that 3.89 for the entire length of the driveway? Maybe you can point this out to us.
Yeah, the 3.89 is so if you see the as you get closer to the house. Section of this is 3. We're proposing a retaining wall for a portion of it to kind of there's a small grade difference. We're proposing a retaining wall that would eat into that 89 centimeters as you get closer to the street. So it wouldn't necessarily be required.
There is a little jog there. It seems to get wider toward the garage.
Yeah, that's 3.89 meters at that jog.
Yeah. The rest of it is
3.98. There's a retaining wall that occupies part of that 3.89 meters. Yeah.
Yeah, you can leave a little bit not done.
Yeah.
So,
they're allowed a certain amount for a walkway, right? Typically,
it's 1.5 meters. But just to be clear, the committee is only dealing with the width of the driveway on the applicant's property, and that may not result in a curb cut at the same width.
There's an existing curb cut that is wider than that we'd like to maintain. We're not proposing to change the curb cut.
A legal curb cut?
As far as I know, I think it's been part of the existing property.
Doesn't necessarily mean it's legal. If it's in the city boulevard, so they may have something to say about it at some point, but just so you're aware.
The other thing to note, we are also, a couple of things we are doing to this to address the stormwater issue is we're reducing the amount of hardscape on the front space anyway from what's existing. What's existing is a fairly wide driveway. And we're also, to the building, we're adding a green roof to the building to deal with stormwater as well. So as far as the stormwater concerns, we feel like we're actually considerably improving the existing conditions, and we think that the extra 23 centimeters that we're asking for also, I mean, it helps us reduce the amount of hardscape on the front lawn by combining the walkway and the drive as well. Yeah.
I'm struggling to understand. So the walkway and the driveway, they're contiguous, right? So it's
we've designed it to be contiguous. So,
but if you added a legal driveway with a legal walkway, the amounts, the widths,
could be
you're still less than that in combination, right?
Yeah, yeah, and we're also less than what the city requires for softscape versus hardscape.
Oh, okay.
And is this? I noticed at the property there's already existing hard surface. Is that going to be reused, or is that going to be?
That's going to be removed. I don't know if it's going to be in shape to be reused. There are a series of flagstones that are there, and I think it's actually.
And have you considered permeable pavers for either the walkway portion or the driveway?
We would look at permeable pavers. Yeah.
Okay.
Yeah.
I'm fine with it.
I'm fine. As long as they.
Again, the whole width is going to be less than what you could leave.
Okay, I think we can take this into committee now. We can take this into committee. Oh, okay. Now, I'll just ask you once again, does the...
Do you need me to concur with the data changes?
May we ask your name and address, please? Come on up to the microphone.
Trevor Dauphiny. I reside at 7 Roxeter, which is one of the back-facing properties that comes off the back of 603, including 5 Roxeter as well. I think based on what we've negotiated with the current proponents of the changes, that we're fine to move forward as the variances. But and I'd like to see, obviously, it was noted. I think that the variance, and particularly the blind on the balcony, was an important piece, and so that's been noted. So, okay.
Okay.
Thank you.
Anything you'd want to add?
All right, then we'll take it into committee at this stage.
So I'd put forward a motion.
Yes.
I think this is reasonable, and I commend the groups for working together to find a solution that satisfies both. So I'd move to approve, subject to second floor deck, rear deck, being maximum 3 square meters, with screening on the east side.
Height?
Height of 1.5 meters is the standard. Let's say minimum of 1.5 meters. Also subject to urban forestry's conditions 2 and 3, and based on the proponent's indication, I would also add that permeable pavers be used for the driveway and walkway.
Thank you.
Combined driveway.
Motion by Mr. Reid. Is there a second to that motion? Second by Mr. Clay. All those in favor? The application is approved. Thank you very much. So that does wrap up.
Actually, through you, Mr. Chair, we do have one little item that I think we can deal with now, if that's okay. While we were in the hearing, we got word that there's an application that was deferred at the public hearing on June 12th, application for 33 Austin Avenue, A119 TEY. The applicants no longer want to proceed with their application, so I need a motion to close the file without refund.
13 Austin Terrace.
33 Austin Avenue.
33 Austin Avenue. Motion, okay, good.
Second.
Motion to close the file, seconded by Mr. Reid. All those in favor?
Great.
The motion is carried.
Thank you. Now you can go for lunch.
Yes.
Yes.
I get